Hear you. Court of Appeals of the State of Michigan is now in session. The Honorable Christopher M. Murray, the Honorable Annika Ledica, and presiding the Honorable Colleen A. O'Brien. All persons have business hearing draw near. Your intention and shall be heard. God save the United States, State of Michigan. The Honorable Court, please be seated.
Good morning, everyone. On behalf of Judge Murray and Judge Ledica and myself, we welcome you here today to our first day of our Lansing case call. I see familiar faces, so I know many of you are familiar with our procedures. For anybody that is new, please know that we are very familiar with your cases. We have read them, read your briefs over several times. Our staff has worked on the cases. We may have even discussed some of them between ourselves already. So we do not need to hear the facts. We're very familiar with the facts of your case. Please just tell us any issues that you think need to be highlighted and why you believe you should prevail before the court today. Also, we do have several cases involving minors and young children, so we would ask that you please refer to them only by their initials. These proceedings will be available to the public to watch on YouTube. So for privacy's sake, please do not refer to them by their name. All right, thank you. And with that, we'll call the first matter, number 1, case number 375088, People of the State of Michigan versus Eric David Ray.
Good morning, Your Honors. Katie Went with the Kent County Prosecutor's Office on behalf of the people. Because appellant is not preserved today, I will keep my remarks brief for the court. I just want to emphasize that when considering whether the defendant met his burden in this case, this court is limited to the record at the in-camera hearing. So the additional materials that have been submitted by the defense that were not before the trial court, I don't believe that this court can properly consider.
That interview, though, was, right? Because I think you said in your brief you weren't sure.
The 2017 interview was...
The other one was too, I thought, because I thought there was a stipulated order done like a week before the judge issued.
If I recall correctly, I did attach it. I don't have it here to review. If I recall correctly, that stipulated order was just the 2017 interview. And that's because they tried calling the CAC interviewer at the time, but the video wasn't working during the in-camera hearing. So the parties agreed to put that transcript before the court in lieu of that particular person's testimony. So I might have that.
From the 2017 or 2020?
2017, Your Honor. I don't believe that we stipulated to put the 2023 interview before the court. I would have to refer back to the language of the stipulation to be sure, but I did attach that to my brief. I don't have it in person with me here, but I believe that it was just 2017 that we agreed to. Any other questions from the panel? Otherwise, I'll rest on my brief.
Well, what about the, I mean, because the trial court's factual findings are hard to overcome. And defendant's brief, they harp on that the victim, when she was saying that she had lied when she recanted, said, but the anal part never happened.
She said, yeah, I apologize.
And that's why I thought there was a 2023 transcript. I thought reading it was, and there was something ambiguous about what she was really saying, but.
Correct, Your Honor. The defense attached the 2023 transcript to their brief, so that would have been brought before this court. That was not, I believe that might have been, if I recall correctly, as part of their preliminary offer of proof to get them to the in-camera hearing, but there was no evidence admitted about those statements at the in-camera hearing once it became the defendant's burden at that point in time to prove falsity, either by a preponderance, clear and convincing evidence. We don't have a standard yet, but nothing was admitted at that hearing about those 2023 statements. The victim was never presented with those statements and asked to explain why she said, I think I used the wrong word at that time. So the trial court was never able to make those factual findings. Seems to me from re-reviewing the transcript that the defense's position was really to say the entire thing was a lie, that she's lying when she recanted, so not to focus in on those specific allegations. Now, I think on appeal, when the trial court found her to be credible, that's the only argument that remains. And as your honors know, deference has to be given to that finding of credibility by our trial court. So I don't believe that they've met their burden in this case to show an abuse of discretion. I don't believe they met their burden at the trial court level to show that it was false, regardless of what standard this court applies. But if the 2023 interview is a concern to this court, I believe the only available remedy would be to remand for us to have that additional hearing to question the victim on that, rather than say at this point that it was reverse the trial court's decision at this point. Any other questions? Thank you.
Thank you. Then this matter will be submitted for decision. Right. The next matter, docket number 2, is case number 371055, People of the State of Michigan versus Davion Deshawn Davis. We have one party present and one that will be appearing remotely. Good morning.
Good
Ms. Young?
morning, Your Honors. This is Laurel Kelly Young on behalf of defendant Davion Deshawn Davis.
Right, you can proceed.
I'm sorry.
You may proceed.
Okay. And I think our strongest issue is the evidence that was allowed in, and basically character evidence or bias or code for, these are just young people running around with guns. And so I think that trial counsel was correct, that should not have been admitted into trial for the jury to hear.
Right. Anything else that you
No.
want?
No.
Okay. Is there any questions at this point? No. Okay, thank you. Let's hear from Mr. Schrotenbauer.
May it please the court, Jerry Skrotenboer for Ingham County Assistant Prosecutor for Plaintiff Appellee. Well, the issue of the gun, we do have the Supreme Court's decision in Hall from 1989 that says that that's admissible. Other than that, I'm relying on my brief and asking the court to affirm.
All right. Okay, all right. Anything further, Ms. Young?
I guess I just would like to ask Mr. Skrotenboer, how does the evidence that was admitted relate to the crime?
All right. Well, I believe that may be addressed in the brief, so we'll take a look at that.
Okay,
All right,
thank you.
thank you. All right, this matter is submitted for decision. Docket number 3 is case number 373196, People of the State of Michigan versus Kelvin George Maker. Morning.
Good morning, Your Honors. Antonio Ruiz on behalf of the appellant. Before we begin, I did want to acknowledge that we do have members of the appellant's family here present today as well. And I'm ready to proceed when
You may proceed.
thank you. Obviously, the court has already stated that it's had the briefs and been able to review them. Just to highlight a few things that I think were important from my review of this matter. In regards to the evidence that was excluded under Rape Shield, I do believe that it prevented the jury from getting a clear picture of the turmoil in the home as well as the motivation of GR in terms of her testimony. Obviously, there's a lot of issues regarding electronics and the use of electronics, and I think that the excluded evidence would have given the jury a much clearer picture of the severity of what the troubling nature was amongst the home. Also, I believe that it would, the exclusion, having that evidence would have diminished the claim that withholding the electronics was used as some sort of extortion technique in return for the sexual acts that were testified to by GR. So I do believe that serves the alternative purpose in terms of diminishing those claims, which I do think is important for the jury to hear in terms of the totality of the circumstances. Going on to the sufficiency of the evidence, I'm sure the court's aware that this relied heavily on the credibility of the witnesses. And I do believe that the number of, although it's not a popularity contest in terms of number of witnesses, I think that there's something to be said with the fact that a number of the witnesses testified as to the credibility of GR at the trial. In regards to, honestly, probably what might be one of the strongest arguments that we have here, or one of the arguments that I really want to highlight is the ineffective assistance of counsel. Your Honors, the objective standard of reasonableness was admitted to by the prosecution is not being met here. And I turn the court's attention to the Akeley case. In that case, there was a small child that was deceased, and the court found that it was ineffective to consult with and or hire an expert witness. That fact alone was ineffective. And that makes sense because you had a manner of death case. In the case here, clearly credibility, I can't see how it wouldn't be ineffective to review by not or failing to review the one piece of evidence that you have that is manufactured. I don't want to say manufactured in a negative sense. It's created to establish the credibility of the witness. We have forensic interviews and CAC interviews for a specific reason. It's so that we put victims and witnesses in a situation to preserve credibility. So for defense counsel to not have reviewed that forensic interview, I think does fall well beyond that objective standard of reasonableness. And I think it's inherently ineffective. And I think the court can look at the Akeley case to kind of mirror that sentiment. And then lastly, in terms of OV8, Your Honors, in terms of being asported to greater danger, greater is obviously the key word here. There's arguments to be made in the brief that it was actually less dangerous because of the turmoil and the physical fear that GR faced because of her relationship with Mona Maker in this matter. That was testified to at trial. And there also was testimony by GR that incidences of sexual assault occurred in the home as well. So it's not any greater of a space or any greater of a dangerous of a space to be at home versus at the camp because there was testimony that those things had happened at both locations. I have nothing further unless there's questions.
Okay, thank you.
Thank you.
You'll have rebuttal. Thank you.
Good morning. May it please the court. Assistant Attorney General Brent Morton on behalf of Iron County. All of opposing counsel's arguments this morning don't matter. The first claim is he's given some good reasons why he would like to introduce these statements, but he didn't explain why it was improper to exclude them under the rape shield statute. This files right along. This was sexual conduct. Sending these images of herself to adult men is clearly sexual conduct. It was clearly excluded and it was proper. And there's no argument this morning that the trial court erred in that matter. With regard to sufficiency, again, we don't have to corroborate her testimony. Her testimony was sufficient to support the elements of the crime, and there was sufficient evidence to find guilt. Yes.
The law provides.
I'm sorry?
The statute is clear. The victim's testimony does not need to be corroborated, and it's sufficient in and of itself.
Okay, I'll move on then. Thank you. With the ineffective claim, he brings up the Akeley case. He's not shown how there's a reasonable probability of a different outcome if the forensic interview had been reviewed. He doesn't provide you with the transcript. He doesn't go through the transcript and show how the defense attorney could have impeached the victim, GR. He refers to Akeley, but in Akeley, the court said, well, there's a reasonable probability of a different outcome if he'd gotten an expert. So I don't think that Akeley really applies. And with regard to the greater danger, OVA, this argument bothers me, that in some way, it's not greater danger to take a daughter who's having an argument with her aunt and take her to a secluded location where he can sexually assault her. And I won't be graphic on what he did. You know what he did. That's not a place of safe, less danger. The case he relies on is a case in which the victim was beat up and the defendant took the victim to the hospital for treatment. He didn't take her to a public place. He didn't take GR to a place where she was safe, where he wouldn't assault her. He took her to a place where he could assault her without any risk of being caught. I see no reason to overturn this conviction of the sentence, and I'd be happy to answer any additional questions. Thank you very much.
Thank you. Rebuttal?
In regards, Your Honors, in regards to a couple of things, I left it for the court to review because I think the briefs do outline it fairly well. But the sexual conduct nature here of these photographs, I think we have to look at this in the context of this was not a sexual act. And I did cite the Sharp case in my brief as well. I think that we can say, well, because it was nude in general, then it's sexual conduct by definition. But I think that's something for the court to determine because as the appellant stated, or the appellee stated in their brief, it's kind of a case of first impression. And when looking at, I guess, today's nature of electronics and behaviors of modern society, is this the type of conduct that was meant to be protected under the rape shield? I don't think it was, but obviously that's why we're here today. In regards to the reasonable probability that there would have been a different outcome, this is not a fact-finding court. There's a review here, and we look at, I think, according to the Trachtenberg case, we look at the ineffectiveness at the time that the ineffective behavior occurred, which would have been at the time of trial, not to review that forensic interview. And it's not that it has to be positive in terms of outcome determinative or a different outcome, that there's a reasonable probability, and not reviewing a forensic interview, I would argue, is very much a reasonable probability that there could have been a different outcome had that been reviewed. When you look at a forensic
Why?
interview, what's that?
Why?
And we don't have it, but the issue is well, understand, but you have to look.
As you said, we are not a fact-finding court.
Correct.
So we don't know what happened during that forensic interview because we don't have it and nobody's told us what happened.
And I think that alone, it falls beyond the reasonable standard, the standard that the court can look to. In terms of what could you do with a forensic interview? You're not looking at the manner in which the individual is giving the interview. You're not looking at the behaviors. There's a lot not only can be seen, you don't even know exactly word for word what was being said. And when you're cross-examining a witness in regards to credibility, you have to have all of the information that was previously provided in an interview. Thank you.
Thank you. This matter will be submitted for decision. Thanks. Okay, the next matter is docket number 5, case number 372268, Jeffrey Gray versus Ashton Marie Brown. We have one party appearing remotely. That's the appellant.
Hi, Judge. It's Stephanie in the clerk's office. It looks like he's there now.
Okay, thank you. Mr. Bender, can you hear us?
Mute myself. Can you hear me now?
Yes.
I can hear you. We can't see you, but we can.
Okay, now,
There you are. Good
got
morning.
it. Thank you very much. Mark Bender appearing on behalf of plaintiff appellant, and I appreciate the Zoom accommodation. I don't expect to run the full 25 minutes, but if I do, I'd like to reserve 5 for rebuttal.
Right.
As the court is aware, this is a case in which my client is seeking uninsured motorist benefits under the policy purchased from defendant Federated. I'm getting and he was in the process of using his tanker, a gasoline tanker, to deliver gasoline to a gas station with one hand on the drop hose, which delivers the gasoline, and the other on the truck itself when he was hit.
Mr.
Oh,
Bendor, Mr.
yes.
Bendor, we know what the facts are. It's pretty straightforward.
I understand.
How do you get around Westfield Insurance Company case? That seems to be about on point as you can find a case.
I don't think it is as controlling as the trial court indicated, and let me explain why. First of all, Westfield relied upon the Rednauer case where there was no contact at all. In addition, when you look at these cases, I call them gray area cases. They involve contact. And the question, but the injured party is not entirely within the vehicle. I don't think you can, factually, these cases have a wide variation. The facts are different, although similar, no question about it. What is interesting is that Westfield does two things. It cites the earlier case, which says that physical contact with the insured is required in order to be upon the vehicle, although the person need not be completely physically supported. That's from the Rollman case, which Westfield decided it wasn't going to follow. Then you have Westfield, and the significant quote from there is that physical contact alone is insufficient to show that the person was upon the vehicle. The problem with Westfield is it doesn't indicate what more, if anything, is required. So you have two inconsistent statements. One is that physical contact is required and doesn't say physical contact plus anything else. So you have what I think are two pretty much conflicting statements which have to be applied factually. Now, the interesting thing is, if Westfield says physical contact alone is not enough, the question is what more is required? And I draw your attention to the Schofield case. It's a Wyoming Federal District Court case. It's not controlling or anything of the nature. But what it does is go through the factors that courts across the country tend to use in what I call these gray area cases. And basically it says, here's the quote: many state courts have adopted a 4-part test. And was there a causal relation or connection between the injury and the use of the vehicle?
What page is that on in your brief?
It's Schofield versus Argonaut Insurance Company. It was attached to the summary disposition brief. And let's see if I can find it is cited at page 26 of our brief.
Okay, thank you.
And I think that pretty much crystallizes when you try to reconcile the cases on point. That seems to be what the Michigan cases are doing. They're looking at how is this injury related to the use of the motor vehicle. And remember, in this case, we have a motor vehicle that is a gas tanker. What my client was doing was using the vehicle in the exact and foreseeable way that it is supposed to be used. In contrast, for example, with something that with a contact that is more incidental and not related to the use of the vehicle itself as a motor vehicle in the way that it's anticipated. I think that's one of the critical factors, and the other factors are similar. But I don't think you can look only at Wakefield and ignore the other body of law that is on point, including the Rollman case, which is also from this court and is equally precedential, which found coverage and again involved contact. And I think as you sort through it and try to make some sense of cases that are difficult to reconcile, I think that's sort of what it boils down to. And in addition, the Schofield case is also significant because it goes through the various definitions of what on and upon mean, particularly in the context of undefined insurance company policy language. And I realize we can't expect an extended definition of a two-letter word like on or upon. But what's significant is that the definitions, the dictionary definitions, which we look to in defining insurance language, what does a dictionary say? Many of the dictionary definitions would encompass this. And I think that's ultimately the major problem with the trial court's analysis, is that it looks exclusively to one case, which has some factual dissimilarities and some factual similarities, and overlooks other cases which are of equal precedential value, which also have facts which are in some sense similar and in others dissimilar. And I think when you look to the very purpose of uninsured motorist coverage, and what it is trying to ensure, this goes to the very heart of it. Because we're dealing with a no-fault system in which people are allowed to have a tort recovery with sufficiently serious injuries in the context of a no-fault act, which requires insurance. And you now have the uninsured and underinsured insurance stepping into the gap where unfortunately people like my client are being injured by people who don't have insurance. And that's exactly what this is supposed to cover. And you look at the other contextual facets of it, not only the definition and everything else, but you've got a situation which seems to be at the very heart of what uninsured motorist is all about. And you have factually the use of the vehicle for the intended purpose with contact with both hands on the vehicle itself. You have the contact. So ultimately, I think that when you look at the overall picture, you have contradictory or conflicting or hard to reconcile case law, which ultimately raises the question, even under Westfield, what more is required? If mere contact does not by itself necessarily create coverage, what else is required? And that's an open question, I think. And my answer is what it requires is that the vehicle contact goes to the very intended purpose of the particular motor vehicle that is being insured. That's a lengthy answer, but I hope it addresses your concern. I'm not sure that I have much more to add, but I'm certainly willing to answer any questions the court might have.
All right. You will have time for rebuttal. We'll hear from appellee's counsel.
Thank you very much, Your Honor.
Good morning, Your Honors. May it please the court, Hillary Ballantyne on behalf of Defendant Appellee Federated Mutual Insurance Company. Defendant is asking that this court affirm the trial court's grant of summary disposition because plaintiff was not occupying the tanker at the time of the accident because he was not upon the vehicle. And as I think we've identified, the only definition in question is whether plaintiff was upon, and he was not. Brother counsel asked what else is required if not just physical contact, and I think the answer lies in the unpublished cases he attempts to rely upon from this court, not from another state, which clearly has no value, and it's support. Upon or on, which is a preposition, means physically in contact and supported by the vehicle. Here, as in Westfield, there was no support. The plaintiff had one hand on the drop hose and another hand merely touching in contact with the outside side of the tanker. There was no support. That is critical. Plaintiff relies on, again, the unpublished cases, but still I think they're worth mentioning because plaintiff is trying to say that something else is required. For example, he relies on Cador versus Northland, which is an Eastern District, Michigan, 2014 unpublished case. And the court said that there has to be some crucial support by the vehicle. Here, there was none. Again, in Cody versus Progressive, which is a 2014 unpublished opinion of this court, the court said that there had to be a level of support. There was no support whatsoever. Plaintiff had both feet firmly planted on the ground. In Westfield, the court said that even merely leaning upon the outer controls of the tow truck was not enough to be sufficient. Here, we have even less than in Westfield. As Judge Murray indicated when we started this argument, there is a case that is not on point more than Westfield. It is controlling. I understand that plaintiff's counsel does not like the outcome, but this court is bound by it. It is on all fours, and for that reason, the trial court correctly granted summary disposition, and this court should affirm.
Thank you.
Thank you.
All right. Mr. Benju, you have time for rebuttal.
I think I've pretty much covered it, although I think it's interesting that the quotations found in Schofield define the very terms, the undefined terms in insurance policy. For example, when it cites the Oxford, Merriam-Webster, American Heritage, a variety of them, indicating position above and supported by or in contact with, outside but close to, in proximity. There are a variety of potential definitions in the Schofield case. But ultimately, I think the important thing, when you're looking at the big picture, the important thing is the connection between the use of the motor vehicle by the insured and the nature of the contact. And this goes right to the very heart of it, because he's using a tanker to do exactly what the insured vehicle is intended to do. With that, I think the briefs and the oral arguments have presented the issue to the court.
Thank you. All right, this matter will be submitted for decision.
How was the drive up this morning? I assume you came up this morning.
Yeah, it was fine. It was fine. I was a little nervous because it was snowing down that neighborhood last night.
Yeah, last night was not fun.
No, it's when you get that little bit of snow. I think it's
Yes.
worse than even northern.
Right.
So yeah, I'd be happy to see you.
Yeah.
Thank you for appearing. All right, that completes our 10 o'clock docket. Do we have anything checked in for 11 o'clock?
you're here for item 7.
Okay. We'll call docket number 7, and we'll come back to number 6. Docket number 7 is case number 369846, Mark Andrews versus State Police. Did you see your opposing counsel? Okay. Thank you. Okay. Just wait a couple minutes then.
Mr. Burton's here, he just got here.
Okay.
If you want to wait or if you want to skip to the next one.
Yeah, I think this is the only one we have 2 parties for so far.
Each day here, here.
Okay. Do you wanna, okay, this out here? Yeah, okay. Yeah, we are.
Yeah.
Yeah. No, no, it's not your fault. You're fine.
Yeah,
11 o'clock,
yeah, you're here early.
You're fine.
Yeah.
Yeah.
We just ran out of customers.
Yes.
Yes. Hello to you who I've never met.
Yeah, nice to meet you.
Jeff Burton, okay.
All right, then we will call number 7, which is case number 369846, Mark Andrews versus State Police. And you can take your time.
Thank you.
Okay.
I'm still marveling at how I got from the car to this courthouse in the wind and the swirling, snow and everything. Okay.
Yeah, it's a winter that never ends.
Yes. All right. Good morning, Your Honors. May it please the court. Jeffrey Berg on behalf of Mark Andrews, the appellant. Your Honors, I'm here to emphasize and give perspective to the arguments made in the brief, not necessarily to add any newer cases or substantive argument, but the what's going on here is the question of whether Michigan law is going to permit the state to retaliate against an employee for engaging in protected conduct, and then for the state to hide behind, in its defense, employment labels and statutory schemes or remedies that are hollow and inadequate. So, Your Honors, the law in all three of my arguments comes from the Michigan Supreme Court. In the first place, the question that the Court of Claims raised in its ruling was whether public policy torts protect a just cause employee. And Your Honors, the law, starting with Sukadolski, and then the Phillips versus Butterball case, and then the Stiegel case, establishes that the wrongful discharge based on public policy cause of action is a tort, which is independent of the employment relationship. And the employment relationship, whether it's a just cause relationship or an at-will relationship, is an agreement between the parties, the employee and the employer, has nothing to do with whether the public needs protection from certain types of conduct, which is what Sukadolski started to tell us, that some actions are so outside of public policy that they need to be prohibited.
But wasn't the point that it needs to be given to at-will employees because they don't have any other protection for review of the termination decision? And a just cause employee, of course, does through a grievance procedure or whatever it is.
Respectfully, Your Honor, no. The point of Sukadolski is that there is public policy. It's for the protection of the public.
I understand that.
Okay.
But the protection is, I mean, I used to do employment law a long time ago, but I still had these public policy, retaliation kind of claims. And I mean, well, let me ask you this. Are there any cases where they uphold a public policy retaliation thing against a just cause employee?
I don't find cases that explicitly state that, Your Honor.
It's not there for them.
Well, but Your Honor, so, okay. I thought of this analogy on the way here. Let's say a thief assaults a wealthy person and takes $100 from them, and the thief assaults a poor person and takes $100 from them. One could say, well, the wealthy person doesn't need the $100. The poor person does. So if you look at whether the act by the thief was wrong, you don't look at who he's doing it to. Just as when there's a tort cause of action that protects the public, you don't look at a job category, who it's happening to. It's for the benefit of the public.
If it's a tort claim, then does governmental immunity apply when the guy sues as the state police?
Does governmental immunity, well,
It's a tort, so of course it would, right?
understood, Your Honor. Well, A was not argued in below. Does governmental immunity apply?
You don't have to answer the question. It's just
At the moment, I don't.
It's something that would come up if you're right, and there's no case law on that either. I mean, it's just I've not seen
It's true, but
kind of a claim with a collective bargaining type or civil service type person, employee.
well, we do have the Marsh case, Court of Appeals case, which gave a right of action to persons under Elliott Larson. And by analogy, that's going to, and those people were Civil Service Commission people. But all that does is illuminate how no matter who you are, what type of employee you are, there are laws out there from the Constitution to statutes to common law that should protect you. And so here, that's what a line of Supreme Court cases has told us. Sukadolski, followed by Phillips versus Butterball Farms, which says that the tort is independent of the employment relationship. And then you have the recent Stiegel case, which is telling us that whatever are the remedies that one might have in whatever one's status is as an employee, a court must look at whether the remedies are adequate. And there's a series of questions that you look at. Is it a meaningful procedure or process? Is it a meaningful remedy at the end? And this court in this case, or excuse me, the Court of Claims in this case, did not undergo an adequacy analysis. And this court, under Stiegel, should send the case back at least for that proceeding. No questions? Thank you.
Thank you.
Good morning, Your Honors. May it please the court, Kyla Barranco on behalf of the Michigan State Police. At issue in this case is whether legal protections aimed at protecting at-will employees who may be terminated for no reason or any reason at all should extend to a just cause classified civil service employee who already received the full protections of his collective bargaining agreement. Your Honors, the answer is no. Mr. Andrews, a just cause civil service employee, grieved his termination to a neutral arbitrator who upheld his termination. He now seeks to essentially go around this arbitration process and ask this court to apply two doctrines that don't apply to him. The first of those doctrines, as you heard from Mr. Berg, is the public policy exception. This exception applies, as Judge Murray was referring to at-will employees who have no other protections. Mr. Andrews did have protections. He used those protections. He went to an arbitrator. He was represented at the arbitration hearing by his union representative, and he lost. The second is the Veterans Preference Act, or the VPA. That statute converts at-will employment into just cause employment. But once again, Mr. Andrews is already a just cause employee. For those reasons, I'd ask this court to affirm, and I'm happy to answer your question.
Argument about under the cooling, about the Civil Service Commission, does that apply to both claims, or the public policy and the veterans?
It would apply to both claims. I would note that it is an alternative ground. So for example, if this court were to say that a public policy, if the public policy exception does not apply to just cause employees, you really don't even have to reach that issue. But under the VPA, it would also apply there. Thank you, Your Honors.
Otto?
Your Honors, the remedies that were afforded to Mr. Andrews were inadequate. Under the VPA, a short filing deadline, no control over the hearing, no explicit damages provision, only a criminal penalty, which is irrelevant to his discharge, and a mandamus remedy only for a hiring situation, not for a firing situation under the VPA. So these were inadequate remedies, and Stiegel expresses that we need to do an analysis of adequacy. Thank you.
This matter will be submitted for decision. Okay. We'll go back to number 6, which is case number 367576, Argent International versus Michigan Occupational Safety and Health Administration. Morning. Running a little bit early, so take your time.
Harking back to high school, my coach said, if you're not 5 minutes early, you're late. After 5 minutes early,
No, you're fine.
off to a bad start. Thank you.
All right, you can proceed.
Good life lessons from the coach.
I try to adhere to those lessons. much to my wife's chagrin. Opposites attract, they say. Good morning and thank you. David Sasanti on behalf of Appellant Argent International. Your Honors, remind me how much time is for this morning?
30 minutes.
30 minutes. Okay. Do I need to reserve any rebuttal at this point?
I'll remind you if you
Okay.
get too far along.
Okay.
At 5 minutes, is that?
That'd be great. Hopefully I won't need that much time, but before I get really into the meat of the argument here, at first glance, this might feel like your run-of-the-mill case. It's the review of a circuit court's review of an agency decision, reviewing an ALJ decision. It's a minor citation in the grand scheme of things, very nominal amount, right? But it's actually a very, very important case for two reasons. One is it involves MIOSHA's attempt to apply a lockout tagout standard that is solely reserved for servicing and maintenance on machines to regular production operations. So why is that a big deal? Well, when you lock out and tag out a machine, you stop production. You literally lock out and tag out the machine. So as the regulation says, someone, presumably a maintenance personnel individual, can perform service and maintenance on the machine. As I'll get to here in a bit, this is a production operation situation where the individual who got injured was operating the machine in the normal course. So if this decision is upheld, then we have a potentially a very looming problem in the state of Michigan, and that is every manufacturer would have to apply the lockout tagout standard that is reserved for service and maintenance during normal production operations. And as many of you probably know, when we're in a world of just in time and everything's now, that can have a very significant impact on operations in the state of Michigan. The second reason that this is important is because if the board's amended decision in this case is upheld, then administrative agencies in the future will basically be required to do no more than say it's a violation because we said it is. As I'll get to here shortly, the board's amended decision, which came about from a remand from the circuit court, is devoid of facts. It's conclusion based. It says this happened, but there's no factual support for it. It says we reached this conclusion, but there's no factual support for it. So there are two really important issues here. One is, does this standard apply to everyday production? The answer is no. And the other one is the amended decision sufficient in light of the standards of the APA and the Michigan Constitution? And the answer is no. So just by way of background, this is a decision that emanates from a decision by the Ingham County Circuit Court affirming an amended decision by the Michigan Board of Health and Safety Compliance and Appeals relating to a citation that was issued to MIOSHA. As I mentioned, the citation relates solely to CFR 1910.147, which involves servicing or performing maintenance on a machine. There was a full evidentiary hearing. The administrative law judge issued a 20-page opinion setting forth 40 specific facts and then providing his conclusion as to why the citation, their citation 1A, citation 1B, was not appropriate. In a cursory 4.5-page decision, the board overturned the ALJ's report. We appealed that to the Ingham County Circuit Court. Judge Jamo from the Ingham County Circuit Court said, quote, the board failed to comply with MCL 2.24.285 and its final decision and order is not supported by competent material and substantial evidence on the record, is affected by a substantial and material error of law and is arbitrary and capricious. Judge Jamo then remanded the matter back to the board, quote, for issuance of an amended final decision and order, including a concise and explicit statement of factual findings and supporting authority consistent with this order, close quote. On remand, the board maintained essentially everything that was in its original decision. And it added paragraphs 3, 4, and 5 with regard to citation item 1, instance A, and paragraphs 10 through 15 of citation 1, item 1, instance B. As I'll talk about here shortly, there were those paragraphs that they added contain no citation to the record, no facts, no deposition testimony, no testimony at the hearing, no documentary cites. It's just conclusion, which the standard is very clear that conclusory statements are not sufficient to meet the standards under the APA. So we, not surprisingly, felt that the board's amended decision did not comport with the APA, so we appealed it again. Unfortunately for us, Judge Giammo reversed this time, finding that what the board had done in the amended decision was appropriate, and then the appellate history from there has gotten us to where we are today. So let's just talk briefly. I'm sure you're all well versed in the standards of review, but I think it's important to frame the issues in this case. So your job as the Michigan Court of Appeals is to determine whether the Ingham County Circuit Court applied correct legal principles and whether it misapprehended or grossly misapplied the substantial evidence test to the board's actual findings, which is essentially a clearly erroneous review. So you have to find that there was a mistake made by the Ingham County Circuit Court. When the Ingham County Circuit Court was reviewing the board's amended decision, that court was required to review that decision in light of the Administrative Procedures Act. And the court was required to overturn that decision if the board's amended decision was not supported by competent material and substantial evidence on the whole record, was arbitrary, capricious, or clearly an abuse or unwarranted exercise of discretion, and or was affected by substantial and material error of law. Substantial evidence is evidence that a reasoning mind would accept as sufficient to support a conclusion. And most importantly, what I mentioned before in the Consumers Power case, this court has said that conclusional statements by an agency will not satisfy the requirements of the APA. There's one more level of review that I'd like to discuss, and that is the board's review of the ALJ's decision. And the City of Detroit case that we cite to in our briefing stands for the proposition that when agencies disregard findings of fact by the administrative law judge and fail to give due deference to review conducted by the ALJ, the agency has acted improperly. So we've got a lot of standards of review going on here. But they all lead to the same conclusion, and that is that the board's amended decision falls short of what's required under the APA, and then by extension, the decision from the Ingham County Circuit Court was improper in essentially affirming that decision because there were, it was clearly erroneous. I think the overarching issue for the court here is what I mentioned earlier, and that is the citation at issue here is based solely on 29 CFR 1910.147. That standard has no application to the citation or to the injury that occurred. The citation was inappropriate. The standard itself says that it, quote, covers the servicing and maintenance of machines and equipment, ... close quote. And the standard itself says, quote, normal production operations are not covered by this standard, close quote. McGarity is the employee who was injured. He's not a maintenance employee. He's a production employee. He was not servicing the press or performing any type of maintenance on the press at the time he was injured. He was running the press in the course of normal operations. And in fact, MIOSHA's supervisor, Lytle, admitted during the hearing before the ALJ that McGarity was engaged in production activity, quote unquote, at the time of the incidents. So given the fact that McGarity was not performing servicing or maintenance work on the press when he sustained the minor injury, 29 CFR 1910.147 by its own terms does not apply to this matter. The MIOSHA wants to take advantage of an exception to that rule that applies to, get the exact language here, servicing and or maintenance which takes place during normal production operations. Again, there was no servicing or maintenance that was taking place. And so MIOSHA's reliance on the exception to the general rule that discusses adjustment or manipulation is misplaced for that reason alone. But the bigger problem with MIOSHA's well, I shouldn't say the bigger problem. Another problem with MIOSHA's argument about adjustments or manipulation is that it has to be an adjustment or manipulation of the machine, not an adjustment or manipulation of material while the machine is running. And in the ALJ's opinion, he set forth very clearly and factually why McGarity was straightening material or adjusting material at the time that the injury occurred. There is no evidence whatsoever that McGarity was doing any type of servicing or maintenance on this machine, including adjusting it, or as the other word that MIOSHA used, manipulating it. So again, that standard has no application to this matter. And so the other argument that MIOSHA makes in support of the application of this particular standard, again, the exception that when someone is servicing or maintaining a machine, they can't bypass a safety guard or place their hands in the area of operation it's essentially a moot point. But even if it did apply, McGarity did not put his hand in the point of operation. What this Sheridan press is, it's a press where the material goes into the front. The operator pushes it in, usually with a tool like this, and there's a roller bar that comes down once to help get the material in straight. Almost like when you put a piece of paper on a copier, it kind of puts it down and runs it through. Then the die that it goes in comes up like this. If McGarity's hand was in the die, he wouldn't have a hand anymore. It would literally be crushed. This is a 300-ton press. His hand was injured by a roller that came down to secure the material well in front of the point of operation. So McGarity's hand wasn't in the point of operation, even if we're going to look at that particular standard. And then finally, with regard to the standard, the ALJ was correct in analyzing, okay, if this standard applies, then the minor tool change exception applies as well. And again, this is all hypothetical because there was no service or maintenance in my view. So this analysis is kind of even if. So the ALJ basically said, even if the standard applies, the minor tool exception applies, and that applies to minor tool changes and adjustments and other minor servicing activities, ... to use the equipment for production. Again, McGarity was not doing any of that. He was operating the machine in the normal course. And as the ALJ found with citations to the record, McGarity was straightening material at the time of the injury. The process of straightening material during normal production is routine, repetitive, and integral to production. And so this notion from the board that the minor tool exception wouldn't apply, even if the standard does apply, is also misplaced. And in fact, the only thing the board really said in support of its decision about this issue is that the straightening that was going on was not done on a predictable basis. They literally just pulled that out of anywhere. That is not, the predictable basis is found nowhere in 29 CFR 1910.147. They just said it's not done on a predictable basis, so it's not routine or repetitive, giving no deference whatsoever to the administrative law judge and his findings as to why it was routine and repetitive. So for a multitude of reasons, this standard is not applicable to this situation, and therefore the board's amended decision is wrong, and the circuit court's decision is clearly erroneous to hold that the board was correct in its amended decision. Are there any questions on that piece before I go to the kind of the second overarching problem? Okay, thank you. The second overarching problem is what I alluded to earlier, and that is when the circuit court remanded this case back to the board, it did so with an express directive to include concise and explicit statements of factual findings and supporting authority consistent with the court's order. I mentioned before that the board added some paragraphs to its amended decision, but there's not a single fact that supports those statements. They're just conclusions. They don't point to facts where the administrative law judge got it wrong. They just make conclusions unsupported by any record evidence. There's also no legal authority whatsoever. They made a passing reference to Part 85, which this case might get a little confusing because there's two Parts 85, one of the APA, but then the other Part 85 relates to essentially the standard. I'm trying to find what it's actually called, but it's essentially it's MIOSHA's general industry safety standards. They refer to Part 85, but they don't expressly cite to provisions wherein the ALJ got it wrong, or more importantly, the provisions that support the decision. And what's interesting and what we point out in our briefing is brother counsel over here, who presumably did the drafting, tells us why he believes the citation should have been upheld, but the board did none of that. We don't know if what MIOSHA's counsel believes is the reasons for the citation to be upheld are the same reasons that the board believes that, because the board didn't tell us that. And the law is very clear that we shouldn't be left to guess as to why an administrative agency has reached a certain conclusion, which brings me back to what I said earlier. If this type of decision is allowed to stand, then administrative agencies in Michigan can just say it's a violation because we said it is. And that's clearly not the law in the state. So there's a clear violation of the APA. And then just briefly, I'll get into the more specific reasons that the board was wrong with regard to instance A and instance B. With regard to instance A, the board said that McGarity was quote unquote setting up the press at the time of the incident, again, without citation to the record. That is not true. McGarity stated clearly during the hearing that he was loading material into the press. He never claimed that he was setting it up. And his shift started at 3 p.m. on the day in question. The injury occurred 3 hours later at 6:30. He wasn't setting the machine up 3 hours into his shift. So the finding of the ALJ is supported by the record. 2, the board found that McGarity was adjusting or unjamming during the incident. Again, this is not adjusting or unjamming material. It's adjusting or unjamming the machine. He wasn't doing anything with regard to the machine. He was adjusting and manipulating material that was going into the machine, production versus servicing. And we cite to a significant section of the ALJ's opinion supporting its finding that McGarity was straightening material, not doing any type of straightening or adjustments to the machine. There's a similar argument that MIOSHA makes with regard to adjustments. And again, it's adjustments of the machine that would be applicable to the citation, not adjustments to material. And so largely for the same reasons that I mentioned with regard to the straightening, that same analysis applies here. And we've cited in block quotes why the ALJ got that particular piece of it correct as well. And again, the board's only retort to that is that this wasn't being done on a predictable basis, which, as I've already mentioned, is found nowhere at all in the standards. And then finally, the board, in support of citation A, says that Argent employees routinely bypass safety measures when operating the press. And we block quoted essentially 3 full paragraphs from the ALJ where he finds that that's simply not true. And what's probably the most frustrating part of that particular finding by the board is that MIOSHA's own expert testified that had McGarity used the safety measures that were in place, he never would have sustained the minor injury. So not only is there evidence that there were safety measures in place to be used while the machine was in production, OSHA supervisor said, yeah, if he used them, he wouldn't have been injured. So he bypassed the protocols that were in place. So there's no basis for finding that citation A, item 1, I'm sorry, citation A or instance A was appropriate. And then with regard to B, the amended decision focuses on whether Argent used alternative measures to provide effective protections in lieu of lockout tagout. But again, we don't need to go there because the machine was in production. It wasn't being serviced. So we don't even need to get to that issue. But if we do get to that issue, then the record is very clear, as we cite in our brief, that Argent did have sufficient lockout and tagout procedures. There wasn't even a need to address whether there were alternative procedures because the procedures they had in place were specifically designed to address lockout tagout. And when the machine is, so that is a misnomer from the board. And then we get to when the machine is actually in production and running, there are safety blocks, like literal blocks of wood that are supposed to be used. And that's where my OSHA safety officer Kibble testified that had McGarity used those blocks, then he never would have been injured. And my OSHA supervisor Lytle echoed that same testimony. So there's no evidence of inadequate safety measures. And then I guess the last point I would like to make is that the board, or 2 points, the board focuses on gravitational hazard. But as I mentioned, it's for the gravitational hazard to apply, the press would have to come down, and that would have to be the potential area for injury. This did not occur in the die area. As I mentioned, the die area goes up, not down. That's not where McGarity was injured. So gravitational gravity as an energy source is not part of this case. And then finally, to the extent the board focuses on ghost cycling, that's a complete red herring because there's no evidence in the record that McGarity was injured as a result of the machine ghost cycling. So to just kind of cap everything off, we have a MIOSHA standard that doesn't apply. We have a decision that's woefully short of the standards under the APA, and therefore we respectfully request that this court reverse the decision of the Ingham County Circuit Court upholding the amended decision.
6 minutes left for rebuttal.
Okay, perfect. Thank you so much.
Good morning, Your Honors. Assistant Attorney General Gallant Fish on behalf of MIOSHA. Part 85, the standard at issue, addresses some of the most serious types of workplace injuries, where the unexpected energization of machines or equipment that have not been properly locked out cause injury during maintenance or servicing. The standard, go ahead. The standard is not an easy read. And because of that, I think this case might appear initially more complicated than it is.
It's not complicated, but the board made it complicated, I think is the problem. Because when you just, your initial introduction, if what you said was accurate, then the company doesn't get cited. They're not setting up the machine. They were moving some material around so they properly went into the machine.
Yes, so there's two
And
different.
That's what the ALJ said. And then what is when you in your brief you cited a statute 408.1044 for the power of the board to basically disregard all the findings of the ALJ. That doesn't say that at all. In fact, when you read the statute, it makes it sound like they can't do it because it doesn't talk about findings and reversing or modifying findings of fact like they do in other statutes. So where is the power just under the APA, or where do they get the power to completely disregard these findings without any discussion, just saying, nope, they were wrong, they were wrong, they were wrong?
Well, Your Honor, the final decision-making authority, I think it's in the structure of the administrative process that the ALJ's opinion is a proposal, and then the board has the final decision-making authority. And I think the unique factor in this case, there is, in cases like Detroit Symphony Orchestra that Brother Counsel cited, there might be findings of fact that turn on credibility determinations. And in those circumstances, there is some level of deference owed by the board to the ALJ who was able to observe the testimony, make the credibility determination. But here, not only do we not really have a credibility determination case, also the ALJ who wrote the opinion was not the ALJ who oversaw the hearing. So we don't have that particular issue, which is really the only instance in which this court has said we really do need to show deference to the ALJ, despite the board having final decision-making authority. And I think the other thing that's important too is the ALJ is the legal expert in this case. The ALJs are licensed attorneys, and not surprisingly, then their opinions look like, in some capacity, judicial opinions. But the final decision-making authority was not given to the legal experts. Final decision-making authority was given to the industry practitioners who make up the board. And so with that in mind, the APA's two basic requirements of findings of fact and conclusions of law make sense. It's not asking for the board to write a judicial opinion. It's asking for the board to give the findings of fact and conclusions of law that supported its decision. And here, as the circuit court found following remand, the court or the board did add in those findings of fact and conclusions of law supporting its decision. And it's true the board didn't add in or didn't include citations to pages of the record like the ALJ did with its 40 enumerated findings of fact or citation to the record. But again, that's not what the APA requires. It requires findings of fact, conclusions of law, and that's what the board provided on remand. So looking to the application of the standard and what you were discussing, Judge Murray, is what does servicing and or maintenance mean? And servicing and or maintenance under the part, if it was just servicing and or maintenance, that'd be one thing. But servicing and or maintenance under the standard has a long series of definitions. And so the board applied two of those definitions here. I found that this was either setting up or adjusting and jamming. And so if it's setting up, the minor servicing exception doesn't apply because setting up by definition is not normal production operations. And so the question is there substantial evidence supporting the board's conclusion here that this was setting up? There was that evidence on the record because Glenn Field, the plant manager, had testified to his recollection being that McGarity had said he was setting up the press when this injury occurred. And then Glenn Field also testified setting up occurs multiple times a shift. It can happen up to 5 or 6 times a shift. And setting up can require reaching in and adjusting the press. And so the fact that this happened several hours into the shift is not determinative because the plant manager testified setting up is occurring on a regular basis throughout the shift. And then also McGarity himself in the statement indicated that he was loading new material into the press and so setting it up when he had to reach in and adjust the material and was injured. And then alternatively, the board found this was adjusting or jamming. And because that is normal production operations, then we look at the exception for servicing.
How is it adjusting or unjamming the machine? If you're just, from my understanding, maybe I'm wrong, the material that's going to be run through, they just have to move it to make sure it goes in the right way. Isn't that right?
That's not what happened here, Your Honor. There is, so the machine, the testimony was that the material is fed into the back, and then as it's fed in, the rollers right before the die area grab onto the material and then feed it into the die area.
Right.
And so if the injured employee here was simply standing behind the machine and feeding it in, that'd be one thing. But here the testimony was that he actually reached under a guard to adjust it as it's running.
But to make the material, I thought it was to make the material straighter or better adjusted so that it runs through the machine the right way.
Yes. And I think
but so that's not adjusting the machine. It's adjusting the material that's running through the machine. Isn't there a difference or no?
I don't think so, Your Honor, because I think it's stretching the language of the standard too thin to say that that's not unjamming. Because so if I had a colleague come into my office.
Unjamming, unjamming is if you have material that's caught up and the machine can't function, so you have to reach in and do whatever you have to do to unjam it. It's not jammed if it's going through and you just have to straighten it. Isn't it? I mean, that's what I said earlier, is that the board is complicating this more than it should for some unknown reason.
I think it is unjamming, Your Honor, because
was the machine not functioning when McGarity, whatever his name was, reached in, or was he?
It was functioning, but it required the unjamming or adjusting to function. And so for it to continue running and properly feed into the die area, this adjusting or unjamming was regularly required. It could be done with the little grabber arm or the stick. Unjamming, I mean, maybe preemptive unjamming in the sense that this would be jammed going into the die area if it was not adjusted or unjammed ahead of time. But again, I think how we use adjusting or unjamming a machine in normal usage is adjusting or manipulating the material inside the machine is synonymous with adjusting or unjamming the machine itself. If I'm unjamming the printer in the copy room, I'm not saying I'm unjamming the paper, I'm saying I'm unjamming the machine. And so I think that is consistent with common usage to say that this is adjusting or unjamming. And then briefly, Your Honors, on the minor servicing exception, the board applied proper legal analysis in determining that this was not was not repetitive because it was not predictable, and explained that routine and repetitive need to have separate meanings under the standard. And the ALJ conflated the two by just finding, because this happened often, that it was both routine and repetitive. Repetitive needs something more, and so found because it was not occurring on a regular, predictable basis that it was not repetitive. And importantly also, the MIOSHA's division instruction on the minor servicing exception asks whether the task occurs on a regular, predictable basis. And so this is not something that should catch employers off guard that this is part of the analysis. So there is that notice provided there. The board also then found the minor servicing exception doesn't apply because there is not an effective alternative safety measure in place, particularly looking at the wooden blocks that were used. There is simply 4x4 blocks, so there would still be a pinch point between the block and the roller bars that came down. And yes, the MIOSHA safety officer testified in his opinion that the blocks would have prevented the injury. Ultimately, the witnesses can provide their opinion. Now the standard applies. The board was in its discretion to make the final determine that there was still danger there, even if the blocks are being used. And finally, as to instance B, which relates to the lack of gravity being addressed in Argent's lockout procedures, Part 85 requires that written lockout procedures identify each potential energy source with the machine or equipment and indicate the isolation and lockout methods for each energy source. Here, Argent's lockout procedures did not include gravity as an energy source, despite the fact that gravity does cause the roller bars to descend. And Argent points out that in the brief that Part 85 does not expressly mention gravity as an energy source, but the definition in there is broad and includes or other energy, a generalized term. And again, in MIOSHA's Part 85 compliance guide specifically identifies gravity. So again, there is notice provided here that MIOSHA considers that a energy source under Part 85. And then the ALJ, in disregarding the fact that gravity wasn't included in the lockout procedures, without the fact that there would be no unexpected gravity energization during lockout. But that's not really the proper question under the part. The question is whether there could be unexpected energization during servicing or maintenance. And here, that clearly is possible because the unexpected falling of the roller bar occurred during the servicing and or maintenance. And so gravity.
Service or maintenance on a machine where the service or maintenance employee comes and fixes whatever the problem is and they start running it again? Not just an employee who's actually operating, doing it, or is that's misguided too?
I don't think so, Your Honor, because we're looking at that specific carve out of where a hand or arm is being reached into the point of operation or an associated danger zone or bypassing a guard. And so, at least for me, when I'm envisioning these types of injuries occurring on the job, I'm envisioning where you're reaching in thinking, oh, I can just move things around in there so this moves properly, and then you're injured because of the unexpected energization that occurs while you're bypassing that safety guard. And so that's why this.
Yeah, but you're not doing it while you're servicing or maintaining, giving service or maintenance on the machine.
And that's, yes, so
operating.
even during normal production operations, if you're performing servicing, so the part recognizes that servicing and or maintenance can occur during normal production operations. So while the machine is operating, and it includes bypassing guard or reaching a point of operation during normal production operations. And so it's not just when everything's shut down and you're tinkering with the machine, but while you're trying to adjust or manipulate the machine or the material in the machine while it's running, which I think, again, when we envision the types of injuries that can occur, that this protects against, this falls squarely into what we would think about, would be reaching in while it's running, thinking that it'll be safe enough, and then because lockout's not followed, the injury occurs.
Is he right that lockout means down the machine? Like, what are those?
No, I appreciate the question, Your Honor, because I think that is, I think inherently feels concerned to think, okay, this is happening all the time, but you need to adjust this material. And now MCOA is saying every time you do that, you have to stop everything, lock it down, disconnect all the power sources, put on locks so that nothing can be activated. And when that is the case is when you get to the point of having to reach into the point of operation or danger zone. And so the testimony here was that the RGent uses several methods of adjusting or unjamming. There's this wooden pole that was used. There's this grabber arm that's used. And then another that works, just reach in and manipulate it by hand. And so what MCOA is saying is if you're getting to the point where you're reaching your hand into the machine, then yes, lockout has to be used. And so it's not requiring lockout in every instance where unjamming is occurring, but yes, it is required if you're actually reaching your arm under the guard and manipulating by hand.
That applies to an employee in production, even though it's not a maintenance person. Like you're not calling over a maintenance person to say, oh, the material is getting stuck in there.
Yes, that's correct, Your Honor, because the definition of servicing and or maintenance under the part is so specific and it contains so many tasks that are included within servicing and or maintenance. So I think if we're looking at just those terms in isolation, then there would be an argument of, well, is this really servicing and or maintenance? Or it includes these terms like adjusting, unjamming, setting up, then it becomes clear this is more than just what we would consider a normal maintenance employee performing. This would include things like a production employee reaching in and unjamming it so it's not getting jammed as it's running.
Okay, thank you.
Thank you, Your Honor.
If you look at the actual citation in this case, Exhibit 1 to our brief, it says Citation 1, Item 1, 1910.147C41, GI Part 85, the control of hazardous energy sources, parentheses, lockout, tagout. So the questions that this panel just posed to MCOA about would the machine have to be locked out and tagged out, meaning shut down, and all the safety procedures that go along with a lockout, tagout, would that have to apply if this decision is upheld? Absolutely it would. Absolutely it would, because I think that the exchange here highlighted very clearly that McGarity was not engaged in service or maintenance. And yes, that definition has a lot of subparts to it, but one of them is not production. And in fact, the standard says it does not include production. So this would create an unbelievable problem for manufacturers in the state of Michigan. And I think the copier analogy is a perfect example. If I put the paper in wrong, the copier's still going to produce a copy. It's just going to be a defective copy. And that's what McGarity was trying to avoid. He was putting material in the press and adjusting it so that he didn't essentially get scrapped. That's different than if I feed a piece of paper into the copier and it jams it so bad that the copier won't work, and now I have to call someone to come fix the copier. That's the standard that they're applying to this situation. It's the fixing of the copier, not the feeding of the paper. And so if they wanted to cite my client for a MIOSHA violation, perhaps there's one that exists, but it's not this one. Because what was happening at the time of the injury is not covered by the standard that is cited in the citation. And it would create a huge issue. And the only other thing I'd like to add is I know that the MIOSHA's relying heavily on this Van Zandt case for the proposition that essentially the ALJ just makes a recommendation. But this court in Van Zandt went through, I have the case right in front of me, several pages of analysis of why the circuit court in that particular case disregarded the findings of the administrative agency. And while we don't see the actual decision verbatim in the opinion, I think it's safe to presume that when this court determined that the circuit court had overstepped its bounds by substituting its judgment for the administrative agency, it was citing to the factual findings of the administrative agency which supported that decision. In other words, there was substantial evidence in the Van Zandt case to support the decision. And when the circuit court overturned it, the circuit court overstepped its bounds. And that is not this case. That is not this case. So unless you have any questions for me, I will thank you for your time and rest. Thank you so much.
Thank you both for appearing today. This matter will be submitted for decision. All right, we'll call docket number 8, case number 369906, Neil Nyber versus the City of Battle Creek.
Good morning. Mark Granzaro on behalf of the plaintiffs appellants. I really don't think I need to take up all that much of your time here today to get my point across, so I'll reserve the rest of my time for rebuttal. This is a case in which 9 private citizens sued to reverse a determination by the city manager to declare the street they live on as a private road. This was after 40 years where it had been maintained as a public road. And the plaintiffs in this case used a statute that is usually referred to as a highway by user statute to make the claim that this was in fact a public road. The defendants in the case, and there, by the way, is also an important constitutional issue that was also raised in this case by way of a 1983 claim, which I'll get to in a little bit. The defendants immediately moved for summary disposition. They did not file an answer. They filed a motion under 4 different sub-rules of 2.116, but it was mostly a 2.116C8 motion, largely because no discovery of any kind had been done. And they made 2 arguments with respect to the highway by user claim. The first was that the plaintiffs lacked standing. The second was that the plaintiffs could not claim the benefit as private citizens of the highway by user statute. The trial court rejected the first of their 2 arguments with respect to standing largely based on a case called Donaldson. But he did in fact adopt as a basis for his ruling the second argument that they raised, which is private citizens cannot claim the benefit of the highway by user statute. And
Ask you a question. Because in Donaldson, that's just in a footnote after they've already concluded that they don't establish on the merits under the highway by user statute, right?
Right.
Right. So, and then some unpublished case picked it up. But here's the thought I had was that whether the trial, I mean, because the trial court used that footnote in the unpublished and said, no, you just can't use the statute because you can't force the government to accept a road, right?
yes,
Yeah. So, but in our case here, we don't even know if the plaintiffs would succeed under the statute. What you need to do first before you can try to force the city to accept it, right? So shouldn't it just go back and let the trial court figure out the merits under the highway by user statute, and then if they say plaintiffs win, then that tees up the question, well, can you really force the city to accept it?
yes, you are correct. The bottom line in this case is it has to be sent back. I mean, this was a very, very poorly reasoned decision. I think the judge.
Well, you can't blame the judge for doing it.
No, you're right.
I mean,
you're right. He was misled by two decisions of this court. One of which has a component to it that I don't think I've ever seen before. It's a decision, relatively short, rejecting the plaintiff's claim, and then there is a footnote on the very last word of the opinion in which the members of the panel ruminate about maybe another reason that we should be skeptical of this decision. And they ruminate on the subject of whether private citizens can in fact claim the benefit of the statute. And what's really interesting to me about the footnote, I tried to get a copy of the briefing in Donaldson when I did the research in this case, because I wanted to know, was this issue raised by the parties, or did they just pick that up on their own? I couldn't get the thing. I didn't get the briefing, but there is some indication, in my opinion, it's just a deduction I've come to, that there was no briefing on this subject. And that the court, after deciding the case, 2-1, by the way, in Donaldson, just latched onto this issue that was near and dear to them for some reason. Now, this is obviously dicta, okay? There's no question about it, but the one quote that is telling about the Donaldson footnote, they say we found no precedents in which the statute was so applied. Well, as I've indicated in my brief, they didn't look very hard. The simple fact is I found 10 Michigan Supreme Court cases before Donaldson that were brought by private citizens invoking the highway by user statute. And I found 8 decisions, most of them later. By the way, just so you know, Judge Murray, you were on one of those I cited. There's a case I cited. I'll just tell you, but his name is Farlow. It's in my brief, but you were on the panel as another indication. Now, none of these cases, as you know, to be honest, they don't say, hey, you have the right. It's just they assumed there was a right. It's never been an issue in these 10 Michigan Supreme Court cases. Okay, and then the Leslie case is the unpublished case, okay, that basically adopted the dicta from the Donaldson case. And the Leslie case is unique in its own right, in my opinion, because I think it has a confession of error right in it. Okay, because the Leslie case, the court says the highway by user statute does not specifically indicate which individuals or entities have the authority to invoke its authority. That's a correct statement. There is nothing in the highway by user statute that limits its reach only to governmental entities. And yet they go on to rule in this Leslie case that in point of fact, it is limited to governmental entities. Well, that's, I mean, it's a disconnect, an obvious disconnect. So the fact is, the highway by user issue has to go back to the circuit court. And just to elaborate a little on your question, there is an implied dedication to the public if the plaintiffs win on their theory. That's the acceptance, and I've cited Supreme Court precedent for that. There is an implied acceptance if, in fact, the plaintiffs make out their claim. So the suggestion, it's only been mentioned in the defendant's brief, it hasn't been elaborated on, but the suggestion that you can't force these private roads on a public entity will have no application if the plaintiffs or when the plaintiffs prevail on their claim. There is a second issue in the case, and it's a serious issue in my opinion, with respect to 1983 and the Civil Rights Act. There was, in my estimation, an attempt to get the plaintiffs to back down from their position. The attempt was made by the city's attorney, who told them, if you pursue this, after they got a letter from one of my clients, if you pursue this idea of making our decision, getting our decision to make this into a private road reversed, we're gonna take down all the trees in your neighborhood, the things.
Well, the statute does say it has to be a certain.
Yes, but the Supreme Court has also said, despite what the statute says, that the highway by user is only as to what is used. And that's something they're going to have to deal with on remand.
They give a big uphill climb on this first.
I'm sorry.
It seems to me, at least, that you have a big uphill battle on succeeding in the First Amendment claim when you look at the letters. Plus, they met with them after the letters.
The city manager's letter in December of 2022.
I read them all. So, you know.
And she says we're shutting this down as a public road in May.
Yeah.
Then the plaintiffs challenge it and she changes her mind. That is in fact retaliation. You can't, how it can be explained in any other way, I don't know.
It doesn't mean you win, even if it was viewed as retaliation.
But the point about the 1983 claim, and this is the biggest point, first of all, obviously, Michigan courts don't deal with qualified immunity all that often. Mr. Curlew and I both know if you go down to Cincinnati and argue a case there, there's probably going to be a qualified immunity case on their docket that day. The Sixth Circuit has dealt with this, and the federal courts have dealt with this way more often than the Michigan courts do. And then, as I pointed out in the Sixth Circuit, it's a 12B6 motion in the federal court. 12B6 motions are not used to decide the issue of qualified immunity. They're really frowned upon because of the need for factual development, particularly on the issue of the violation of constitutional rights. But the fact is that this C8 motion, the trial judge did what you would think was impossible to do in any legitimate approach to these problems, because the C8 motion is based totally on the allegations. And the trial judge managed to dismiss the plaintiff's case on the 1983 claim without ever examining the complaints. That is not the way C8 motions are to be treated. And as I've documented in the brief, all of the elements of a 1983 anti-retaliation claim under the right to petition the government for grievances and the First Amendment, all of the elements have been pled in this case. And the 1983 claim has to go back as well, the way that this judge decided it, because the allegations are there and that's all that is required. And if you have any other questions.
Thank you.
Good morning to the panel. Douglas Curlew on behalf of the defendants appellees, Battle Creek, Flurry and Steel.
It's interesting. I'll go in reverse order, actually, because it's interesting that plaintiff's counsel brought up the Sixth Circuit and qualified immunity. I was there arguing qualified immunity in the Sixth Circuit a week ago on a 12b6 motion, a dismissal. So I am familiar with the law in that particular regard. Counsel is actually right that there is a case law in the Sixth Circuit that qualified immunity should not be addressed in dismissal in a particular circumstance. It's where there needs to be factual development to justify the defense of qualified immunity. Where the facts are already on the record before the court, they can certainly do it on a 12b6 motion, or in the equivalent of Michigan law would be the C8 motion. So that is not the rock solid barrier that is suggested here. And in this case, there's been no suggestion as to what else other than the letters and the exchanges of letters would be suggested as far as evidence in the First Amendment claim.
And the letters were submitted to the trial court, correct? Or not?
All of them, yeah. In fact, I believe it was, they were attached to the plaintiff's
I was wondering about
complaint.
the complaint. So it's part of the allegations anyway, really.
Yes. So that's not really a barrier. And just to keep going in kind of the reverse order, getting back to the front, as far as the 66 feet wide thing and the need to widen the road, it is what the statute says. The roads are 4 rods, 66 feet. The cases that are cited in the reply brief by the plaintiffs to say that that isn't always required, in each of those situations, and I refer particularly to the Smith versus Rogers case and the Eager versus Mackey case, in those cases, it was a situation where the citizen had offered the road to the public entity, but what they had offered was not a 66-foot road. They had offered a smaller road. And in each of those cases, the government had accepted the smaller, what had been offered. And what the holding was that the government was then limited to what had been offered and what they had accepted. That's not a situation here where the government is or they're attempting to force the government to take a road. Well, if the government is going to accept it, they're going to accept it as a 66-footer under the statute and have the right to do so. But of course, in this case, they're not accepting it, which brings us back to the beginning point, which is the statute. And, you know, we've had some talk today in a couple of the cases about finding cases that were on all fours. We have the Donaldson case, which is perhaps the most on all fours case I think I've ever had to argue to this court. We've got property owners who have a road that they want the government to have to take care of after the government was taking care of it for a long period of time and then realized their mistake and to save costs decided we're not going to take care of it anymore. And we also have the dissenting neighbor in Donaldson, just like we have Kelly Moody and her husband in this case. The case couldn't be much more exact, and the result would be the same. Again, as far as the record and this idea of going back to the lower court, the question comes in any case, was summary disposition premature when discovery wasn't completed? Well, okay, you had to present independent evidence of whatever other discovery you would do.
But wasn't Donaldson, and I could be wrong, but I thought that the trial court granted summary disposition to probably the defendant, saying that the plaintiffs couldn't establish a claim under the statute. And we don't have that here, right? I mean, trial court didn't dismiss it on that grounds.
It did, but the city and the defendants argued that they couldn't meet the criteria under the statute. And of course, as this court knows, you can always affirm the decision on any ground that's demonstrated by the record. And we have a record in this case, created almost entirely by the plaintiffs themselves, that demonstrates they can't show the criteria. Donaldson points out, and in fact, the reply brief is very heavily emphasizing Bain versus Fry. It agrees on the same point. You have to have had a hostile exercise of authority over the road. Donaldson points out in a situation where the city has been providing these services all this time, it's not hostile. They've been enhancing the rights of the original owners in the roadbed. So that doesn't qualify under the statute.
And I'm sorry, so this was in the trial court argued on the merits about it was raised, but it wasn't decided on those grounds.
Now, I must,
No, I just want to make sure I didn't.
Right,
I
and the
focused
court,
on this other issue more than I did on the.
right, and I would have the court check me on that because I was not the trial attorney and our firm was not the trial firm. It was done by the city attorney. So please double check me on that to make sure. But as I understand it, this was part of what was argued in the trial court. It was an alternative ground, and that's why I argued it as such in the briefing that I did. Again, the same thing as with the First Amendment claim. What else? There's been no offer of what evidence. In fact, they didn't even argue in the circuit court that they needed more discovery. I didn't see that being raised by the plaintiffs in the case. So I don't see how that works. As far as the other thing, I just wanted to hit from the one other additional point from the reply brief, of course, what I didn't get to reply to in writing, is they talk about the issue of, well, the statute doesn't say who can and can't use this highway by user statute. And so you can't say that a private citizen can't use it. And of course, the citation by the circuit court was to the unpublished case in Leslie. I understand unpublished cases are not binding, but they can be instructive. In my office, I have two folders. One has cases where this court says we shouldn't listen to unpublished cases, and the other one says unpublished cases can be informative and instructive. I use whichever one I need at the time. And in this case, I will say that the Leslie case versus Sault Ste. Marie can be very instructive. What they did in that case was they said the statute doesn't tell us specifically who can and can't use the statute, but they read the next statute, which is part of the same series. What they did was read it in para materia. The plaintiff is claiming that they read a limit into the statute that doesn't exist. No, what they did was read it in pari materia with the other statutes in the same series and said those other statutes all talk about townships making these claims. In fact, I found it kind of ironic that they argue in their reply brief heavily on the Aranac Township case. They said, well, there were private plaintiffs in that case. Well, there were, but they had joined with the township. That's the way it's phrased in the opinion. Aranac Township was the one that was suing under the statute, and the defendants all joined in with the township. So it was based on the township making the claim, not simply private parties. And my final point would be that's the same thing that I outlined in the case by case by case in my brief. The cases that are cited by the plaintiffs for the supposed previous uses of the statute by private parties were all instances where it was used by private parties against other private parties, not where they were trying to force the government to take possession of a road as a public highway. If the panel has no further questions, I will sit.
Okay, thank you.
Thank you.
Let me begin with where he left off. The suggestion that 22120, the highway by user statute, is somehow impacted by 22120A is something that was in both Donaldson and in Leslie, and it's completely wrong. Because if you look at 22120A, it applies only to townships. It applies only where there's 51% of the people with property on the road have given their approval. None of that is in 22120, the highway by user statute. This was a serious construction mistake made in both Donaldson and in Leslie. There is no such connection. And think about what his argument means. If in fact, these two statutes are in pari materia, and that 220A impacts the reach of 220, every single case that has been brought under the Highway by User Act by a village, by a city, by a road commission, or by a county was wrong. Why? Because 220A limits its reach to townships. It's a really dumb argument, okay? And it doesn't work. Okay, now let me go back if I can. The suggestion Mr. Curlew has made is that some of the cases I cited where there was a private party invoking the highway by user statute, they were suing other private parties, and that to him is something different. Okay, well, what Mr. Curlew is suggesting you do is not only write into the highway by user statute a unwritten limitation, that is, it only applies to governmental entities, but you also have to write in, if you want to accept his argument, you have to write in an exception, unwritten exception to the unwritten rule. And that is, it does apply if one private party sues another private party. So if you're into judicial reworking of statutes, Mr. Curlew is your guy. The fact is, it doesn't say it, and that's how Leslie started out its opinion. Okay, now let me talk about Donaldson, because understand what Mr. Curlew is asking you to do with respect to Donaldson. He's asking you to decide on the merits of the plaintiff's claim under the highway by user statute. He's asking you to decide that on the merits when they filed a motion without any discovery. So it's not a question of a C10, because that's where it would be, a C10 motion. It's not a question that discovery is over. No, discovery has not yet begun. And he's asking this court to take up that issue when it wasn't even decided by the trial court. That is not the way this court operates. Your initial question, your initial skepticism, it seems to me, about this case was correct. This case has to be sent down for the determination. But the suggestion that Donaldson is directly on point misses Donaldson itself, because even if you look at the merits of this case, okay, and you took this opinion, which is, according to Mr. Curlew, directly on point, that the Michigan, this court said, there would be a different set of circumstances in other situations with respect to the other elements that the plaintiff failed to establish in the Donaldson case. And I'm quoting. For example, the Road Commission might have purchased a parcel of property from the United States Forest Service for use as a public park and maintained the road as a means of public access to the park. That's in Donaldson. Donaldson, maybe another frolicking detour by the court, but it's an indication that there are facts which could exist that would have led them to apply the highway by user statute. Well, guess what? We have exactly that circumstance in this case, because what the plaintiff has alleged in the case is, in fact, that there was a gate put down to the public park, which is right at the foot of Lakewood Drive. There was a gate put in for use by the public. So the distinguishing feature that's actually talked about in the Donaldson case is in this case. So the suggestion that you can reach the merit of this case on the basis of Donaldson when it wasn't decided by the trial court and it wasn't the subject of any discovery should be off the board. And finally, the last thing I would say, again, understand, we're not here to prove a case, especially with respect to the 1983 claim. Mr. Curlew is suggesting to you that we somehow dropped the ball because we didn't establish the claim. The simple fact is, and you can read his motion, or his predecessor's motion, the motion with respect to the 1983 claim was predicated solely on C8. The trial judge's ruling with respect to that allegation was predicated solely on C8. And that means it's based solely on the allegations that were made. And I won't go through them, but if you look on my original brief in this case, on pages 34 and 35, those are the allegations of a 1983 claim. And that's all the plaintiffs had to do in this case, allege. Again, this was a C8 motion on a federal civil rights claim, and that's what it should have been confined to. If you have any other questions. Thank you.
Thank you both for appearing. This matter will be submitted for decision. All right, the next matter is docket number 9, case number 376742, Henry Dixon Curse Minors. We have one party endorsed for oral argument, and that's to be remote, correct? Yeah.
Good morning.
Good morning. You may proceed.
May it please the court, Attorney Dorothy Dean, appearing on behalf of the appellant mother in this case. Your Honors, this is a case involving a mother who is facing 15 years of incarceration. There were suitable parents that, a suitable grandparent that came forward and is willing to take on guardianship. I just would like to highlight that based on that, guardianship is considered a viable means of making sure that the child's best interest is looked at. This case is very, to me, unusual in the fact that the guardian ad litem spoke very highly against termination. The therapist came forward speaking against termination. We have a 6-year-old and a 13-year-old. There are bonds between these children and the mother, even though the mother is facing incarceration. I point the court to case Baham, Baham 331 Mishap at 737, where it was a similar case where a mother was facing 20 years of incarceration. This mother is facing 15 years of incarceration. This court determined that because the mother supported the guardianship, even though there would be long incarceration, there was nothing wrong with doing a guardianship. So we are asking the court to reverse this case to allow the guardianship to be the means, the least restrictive means for this parent so that the parent-child relationship can stay. As again, there's a strong bond between the mother and especially the 13-year-old. The guardian ad litem stated that it would be detrimental to the 13-year-old to terminate the rights. So I'm here today just advocating on behalf of mother and asking this court to not terminate and to determine that it is not in the best interest to terminate and to allow the guardianship to be put in place. Thank you.
Any questions? All right. Thank you for appearing today. This matter will be submitted for decision.
Thank you, Yana.
And there are 2 remaining matters that do not have anyone endorsed for oral argument. We will submit them on briefs. Docket 10, case number 376197, Henry Martinez Peralez Minors. That is submitted for decision. Docket number 11, case number 375831, Henry LR will be submitted for decision.